So for the rest of this lecture, we'll focus on first negotiations on climate action, and then we'll look at disputes relating to climate action. These negotiations, I already alerted you of that just before the break. These negotiations are happening. One of the negotiations, which, in all fairness, I must say, are at this very moment are somewhat subdued, not very active. And I'll explain in a moment why that is. Are the negotiations on environmental goods agreement? These are negotiations that are already going on since July 2014, and that involve 48 WTO members. And the purpose of these negotiations is to eliminate, just like we did for information technology products, to eliminate tariffs on environmental related products. And examples, easy examples of these products are, of course, mills and solar panels. But a problem that the negotiators have been countering, that there is disagreement as to what actually are environment-related products. You can have a broad definition of that, and you can have a narrow definition. A narrow definition would be windmills and solar panels, and that would be a narrow definition. But once you start talking about inputs in these products, inputs can also be used differently, the discussion becomes much more difficult. So an important reason why these discussions, which have now started more than 10 years ago, have not come to a conclusion, is the disagreement on what are environmental related products. Another reason why the negotiations have somewhat gotten off track is because some of the participants in these negotiations put on the table the idea, okay, it's all very nice to talk about environmental goods, but what about environmental services? As you probably know, many developed countries are more service suppliers, service producers than they are goods producers. So they wanted to also include environmental services. The developing countries involved in these negotiations also said, well, listen, it's all nice that we can buy your windmills, we can buy your solar panels, and that this would be duty-free, that's fine. But there are environmental services that we're really interested in. And whether to include environmental services in these discussions on liberalization, has been very controversial. Yeah. So, okay, these are formally still ongoing, these negotiations. Yes, please.
What exactly do they need environmental services?
Well, environmental services go from sewage services, water cleaning, to engineering, engineering for that particular environment, environment tasks. Oh yeah, no, but people usually think about sewage and water cleaning. That's an important environmental service.
Could they have not also included technology?
Excuse me?
Could they have also not included technology in this?
Technology?
Yes. So if say talk about wastewater treatment.
Yeah.
Developed countries have more sophisticated systems of this. So the private players who have like a hold on these.
Well, that's what makes these discussions and some developing countries, some are want this trade to be easier, others are resistant, because if wastewater treatment or supplying safe drinking water, well, I mean, they're French and Spanish multinationals that are very well known in Latin America, but just for those that you teach, if you teach international investment law, there are a number of investment cases that deal with these suppliers of environmental services, water cleaning, water supply, clean water supply, and have little problems because they then start charging higher fees to cover their costs and so on. So countries want to have their own, to protect their own water cleaning companies. Yeah. They could not stand the competition of foreigners. You keep your market closed. Okay. What else? We have structured discussions. Tell me. Sorry, say again?
Any particular reason why the 48 WTO members are on board for this agreement?
Well,
That's a very less number.
I don't have a particular explanation for this, perhaps. You see that they started in 2014. And in 2014, these issues were perhaps a little bit less important than they are now. So they started with, well, actually, they didn't start with a 48. The number went up a little bit, but then it did not anymore. Because of all the internal disagreement, and I think parties sort of lost, or members, WTO members lost confidence that this would ever be successful. But I share your surprise. Why is not everybody in these, at least in negotiations? I share your surprise. And I don't have the best of explanation for that one. It's interesting that the numbers that we will see in the other plurilateral negotiations are much higher. And now to make it worse, 48 also includes the member states of the European Union.
Oh.
Okay, all right. Structured discussions on trade and environmental sustainability. We've had these discussions since November 2020. There are 76 WTO members involved. And be careful, when you look at that number, don't necessarily compare it with 166 WTO members. There are, perhaps a painful thing to say, but there are just a number of WTO members that are very, very inactive. Yeah. Yeah, because the WTO membership also includes quite a number of island states in the Pacific. Do we often see them take the floor? No. African least developed countries? No. The group of least developed countries is strong, but that's because there's some strong leaders in that group. Yeah? So 76 is not bad. What is bad is that India is not there. Yes, you can have your chocolate. These discussions, these structured discussions, understand negotiations. Yeah. are coordinated by Costa Rica and Canada. This is what you see with these structured, with these plurilateral negotiations. They often have a coordinator or two coordinators, or the next one that we will discuss, actually multiple coordinators that sort of drive the process. There are, in 2022, members involved set up 4 working groups. And I include this in my slide just to indicate what sort of the topics are that are being discussed in these discussions. There's one working group on environmental goods and services. And you see, this is sort of well, these have not been declared dead. Probably all the work is being done in the context of the structured discussions. And they include services. And with many more involved. The trade-related climate measures is another topic. And then the focus is primarily on the WTO consistency of trade-related climate measures. The circular economy and circularity. This is, by the way forward. That we recycle much more. And that we reuse. And that is a specific topic addressed by this, in this structured discussion. And finally, subsidies. That's what you would expect, right? That subsidies are also being discussed. Now, what else do we have? We have an informal dialogue on plastic pollution and environmentally sustainable plastics trade. That's a mouthful, so let's just call that the plastic dialogue. That started in November 2020, involves 82 members, but it's coordinated by Australia, Barbados, China, Ecuador, Fiji, and Morocco. So, yeah. Always look at these countries, developing, size of the country, and you find a beautiful mix. Also, continents, all continents are big countries, small countries, they're all there, yeah, as coordinators. Now, there are 3 work streams. Again, I put this in order to give you an idea. The fact that there are 3 is not the, but to give you an idea of what these negotiations are about. And they're about data collection, because there's just not enough data about trade in plastic. There's the discussion of cooperation with other international processes in the context of the UN. And you may have become aware of this because just before Christmas, the negotiations in the context of the UN on a plastic treaty failed. Yeah. They will continue negotiating, and some sort of compromise will eventually have to come out. But the WTO is not the prime forum for negotiations on plastic. It focuses on the trade aspects of plastic, trade in plastic, but there's a much broader discussion on the use of plastic and so on. That takes place in the UN, and of course, there's a working group, a working stream. Again, another word that diplomats invent. It's a working group, but they talk about a working stream. Cooperation with international processes. And then this is sort of related to the data collection. It's the identification of environmental sustainable trade policies and mechanisms. And so it's a sharing of information. What do you do? Does it work? So they collect information. I hope you've noticed that there's no work stream on defining new rules. No. Yeah. It's less ambitious than that. Yeah. Partly because the new rules will have to be agreed on elsewhere. And then we have finally the fossil fuel subsidies reform dialogue, or talks. They started in December 2021. And as you will see, I mean, these are, with the exception of the very first one, it's 2020, 2020, 2021, and the last one will even be more recent. Fossil fuels subsidies reform involves 48 WTO members. It's coordinated by New Zealand. The ambition there is to phase out, that's a huge ambition, phase out fossil fuel subsidies. At the moment, there are fossil fuel subsidies for $500 billion a year. You remember what we said when we talked about COP29 and how much support the international community is promising by 2035? 300 billion. That's of course international support, but if you look at the domestic level, there are more subsidies given for the use of fossil fuels, carbon emissions. There are more for that than for environmental purposes, for fighting climate change. But I've said that, I'm starting to repeat myself. It's time that this course comes to an end. I've also already said that this is socially very, very good. Because the poorest in your society are the ones that depend on these fossil fuels. Okay, also the transport sector, they also like it, but often the poorest depend on fossil fuel subsidies, gasoline subsidies, in order to be able to drive a car, to drive their motorbike, to heat the house. Take away these subsidies, and you really affect people in their livelihood. Now, what else? I'm going to focus on two ministerial conferences where things are supposed to happen. And I will say something positive about the first one and something much less positive about the second one being the most recent one. The ministerial conference in Geneva in June 2022, C12, was positive. You find that in the outcome document, paragraph 14. Was positive because there was an explicit recognition, and now you would say, oh, well, that took them a long time to come to that. An explicit recognition of global environmental challenges, including climate change. Okay, thank you. We already knew that, but now there's an explicit recognition. The outcome document, paragraph 14, also notes the importance of the contribution of the multilateral trading system to promote. And then they don't refer directly to the climate, to addressing the climate crisis, but more generally, and that's fine, to promote the UN 2030 agenda, so Sustainable Development Goals. Finally, they note the role of the Committee on Trade and Environment. It's a standing forum dedicated to dialogue between members on the relationship between trade measures and environmental measures. It's interesting that they refer to the Committee on Trade and Environment, multilateral forum. So I'm sure that there may have been references to other plurilateral fora in the draft text, but that India said, no. We only recognize the importance of the multilateral context. All right. I would have wanted to see much more. Yeah. And we need much more in terms of commitment to address the climate crisis. But this is what we got. And then we were all hoping that we would get more out of MC13. There's no reference to climate. And there's only one reference to environmental sustainable development. It's disappointing. Very disappointing. Yet, there are all these negotiations going, yeah? But somehow, well, many of these negotiations are plurilateral. Huh? So in a document that needs consensus to be adopted, the ministerial declaration needed consensus to be adopted. One can imagine what happened. So all references to plurilateral negotiations were avoided. Last thing I want to cover with you is WTO disputes on climate action. Disputes. Not negotiations, now disputes. And the first thing, and now I'm coming back to you, the challenges facing the WTO dispute settlement system. Floor is yours. What are the challenges facing the WTO dispute settlement system?
Let what impresses.
We had the floor.
First, as ma'am pointed out, second is willingness of the top leadership in US and Russia to take efforts towards combating climate change, towards any kind of cooperation.
Okay, right. You combine two interesting points. I wouldn't put too much on the second one, namely the invocation of national security as a justification for what would otherwise be GATT inconsistent measures. Yes, that is a challenge to the WTO dispute settlement system because Russia and the United States, and particularly the United States, they're the more important player, say there's no jurisdiction. But indeed, please.
I think the biggest problem is how the WTO is such a self-contained code. Because the WTO doesn't have any environment or climate-related agreements or any like covered treaties, with the exception of maybe 20. And because of that, even though appellate bodies and panels can look at environmental issues, they hesitate to go outside the framework of the WTO to look at like the Paris Agreement or other MEAs, and they have to sort of be constrained to the limited covered agreements.
Yes. Otherwise, act outside. Never do that. But you refer to the relevance of the Paris Agreement, or the relevance of any other multilateral environmental agreement, and there you didn't say that it had no impact or no role to play. But I would add to what you said that in interpreting WTO obligations, the rules that you find in the Paris Agreement, to the extent that these rules are, definitely the extent that these rules are a reflection of customary international law, play a very important role in interpreting the WTO. And when the appellate body in US shrimp gave a broad interpretation to the concept of exhaustible natural resources, they referred to environmental agreements. Even in environmental agreements to which the United States was not a party, it's one of the parties in this case, they referred to international environmental agreements in an effort to interpret the concept of exhaustible natural resources. So, but the challenges facing the WTO, yes.
Cases like Malaysia accepting. Actually, the dispute settlement has become a defunct machine because even if the panel gives this report, we have only few cases where both parties accept the report and they keep on appealing to the void. So even though we may mention that the appellate body is not functioning, the whole functioning of the actual panel is also rendered ineffective because.
Thank you. Thank you. Thank you. And that seems obvious to you, right? It is obvious, but when the crisis broke in 2019, the first months into 2020, there were ambassadors that said, "Oh, Peter, don't worry, panels will resolve the disputes." No, no, because if you lose at the panel stage, you appeal, and you appeal into the void, and that has the good consequence for the loser that the outcome will never become legally binding. That's what we've, as you described, that's what we've been seeing. Now, okay, there is now also, no, let me talk about the MPIA at the end. Now, challenges facing dispute settlement, I think we've said enough. And there are ongoing negotiations on, at MC12, they agreed that they would make a real effort to have a fully functioning dispute settlement system again by the end of 2024. Okay, that's behind us. Yeah. And efforts were made. Now that's another lecture. But yeah, let's go and look at India and dispute settlement. I'm abusing the opportunity to talk a bit about India and dispute settlement, even outside the field of the action against climate change. India has been a complainant in 24 cases and a respondent in 32. Out there, bring some cases that you can improve your statistics. Because when you bring a case, statistically, players statistically win. That was not the case in the EU palm oil case, or at least not as much as I would have wished. Yeah? But statistically, you win. Why is that? Not because there's some sort of bias for complainants, but before you bring a case, you've thought carefully about it. Yeah? And you pick your measures well. And you. So, this is my advice to government. Bring some cases. Now, of course, this is difficult to give that advice in light of the fact that they may win before the panel, and then the other party will appeal into the void, and then they've got nothing invested tremendously. Solution? Right? Okay, yes, of course. And if you bring cases against a non-MPIA member, you still have that problem. But the number of MPIA members and the trade with between India and these MPIA members is considerable. And there are problems in that trade. So these are cases that you could bring. Now, this discrepancy between winning and losing was something that the European Union was struggling with. In the early years, they lost the banana case. They lost the Holman's case. Although there, the saying goes, they lost the battle but won the war. In the sense that the appellate body completely agreed with the way in which the European Union interpreted the SPS agreement. And then applied that interpretation and then found that the EU was wrong. Yeah? But the interpretation of the EU, but anyway, they politicians, it was a loss. Dispute settlement in the late 90s was getting very unpopular in Brussels. Oh, it's losing, and we're losing on important things. And then DG Trade said, aha, we'll start bringing cases. And even though cases of which the industry said, no, don't bring it, because you're waking sleeping dogs. Which case am I referring to? The US 1916 Act, which is indeed an act of 1916 which criminalizes dumping. Hadn't been applied for decades, that act. But it was still on the books. Somebody at the commission had found it, and they said, ha, well, we'll get a win on that one. The industry, the European industry said, no, don't do it. They may get inspired and they may revive this criminalization of dumping. But yeah, the European Union won hands down with on that case. Anyway, just saying that India would not be the first one to start bringing cases in order to. But the condition, of course, is that you join the MPIA because otherwise you're nowhere.
So if India joins MPIA, all the major countries except the US would be then party to MPIA, and then any effort that could have been made or any possibility of the appellate body then being revived would be lost, because then if US is the
that's the argument that Indian officials make. Yes, but honestly, have you been following the negotiations over the last 2 years? This is going nowhere. And certainly now under the Trump administration, they won't even negotiate anymore. Yeah? The Biden administration at least had the courtesy of negotiating, and then they, with regard to appellate review, they made impossible proposals. Clearly, that's it. In the text, they talk about appeal/review. And the reason for that is that the United States doesn't really want any appeal. They want some sort of review system, which may be a review by a political body. And to the extent that they do agree to some sort of appeal, it is on an ad hoc basis. The appellator will change every time. And the grounds of appeal are even more narrow than the grounds for annulment in exit proceedings. And as your professor will tell you, very, very narrow. If I make a joke out of it, you have to kill your mother before you can bring a case. Yeah? Do something. The panel has to do something very, very bad in order, according to the United States, to then have the right of an appeal, and that appeal will be dealt with by somebody who's ad hoc appointed. The agreement of the two parties, so that will be interesting too. Now that was, at least they were on the negotiating table. The Trump administration won't even show up. My guess, it may surprise me. They probably will surprise me on other points. Now, notable cases in which India was involved, and yeah, I mean, I hope many of them ring a bell, and if they don't yet, they might be in the future. India solar cells, well, we discussed that one. Yeah. US carbon steel, India agricultural products, EC tariff preferences. EC pet linen. EC pet linen actually was the first case in which zeroing was an issue. India was the first to complain about zeroing. Zeroing is this methodology to calculate the dumping margin. Yeah? Which is extremely controversial because one of the reasons why the United States blocks the appointment of appellate body members is because they have a fundamental disagreement with the appellate body's case law on zeroing. India was the first one to bring up that issue, but not against the United States, but against the European Union. And the European Union lost. And they didn't immediately comply, so there was an Article 21.5 case brought by India on this, and the European Union lost again, and then they stopped zeroing. And only the United States continued to zero, and the United States has been condemned, has been told that couldn't zero again and again and again, still doing it. Okay, others, India quantitative restrictions. Sorry, that should be plural restrictions. That was the end of the invocation of balance of payments exception now. It's a case, I was legal advisor on that one. That was a very interesting case. US shrimp, where India was one of the 4 parties, one of the 4 complainants. Turkey textiles, also an interesting one. And US shirts and blouses. I'm so happy that India appealed that case. But it's a very strange situation. India won at the panel stage, and then they appealed. They appealed, this is in the early years, you can see the number, DS33. They appealed because they disagreed with some fundamental systemic issues. One was the burden of proof. The other one was judicial economy, whether a panel can exercise judicial economy. And I was a legal advisor of the appellate body at the time, and I remember the appellate body members to be so happy that this case came, because they could say, and this was early years of the system, they could rule on what the burden of proof is in WTO dispute settlement. This had never been decided. In all these GATT years, panels had never made a pronouncement on who has the burden of proof. It wasn't done. So the appellate body for the first time could say, well, the burden of proof is on the party that claims the affirmative of an obligation or a defense. And then judicial economy. And India didn't agree with that in the particular context of this case. Judicial economy, the idea was, no, judicial economy cannot, a panel has to look at everything that is put. Well, the body said, no. One can exercise judicial economy. If the beast is dead, it cannot be deader than dead. Yeah. If you have 5 claims of inconsistency and claim 1, claim 2, do you really have to go to claim 3, 4, and 5? Yeah? No, a panel can say it's enough. We've given the respondent enough of a beating. Yeah. But of course, you have to be careful that you don't exercise false judicial economy. Right, now, let me get back. I love talking about dispute settlement. But let me get back to climate action. And, it's the same one. This is the dog that has a specific, you can give him a certificate. Okay. In how many panel and appellate body reports was there a reference to climate change? Now, I didn't take all these reports and start, so this is what you can do with modern technology. And I'll let you discover this, but I'll interpret the list already by saying that the only report in which it was climate change was there big time was the India solar cells case. There, the panel referred to the concept 110 times and the appellate body 78 times. Brazil taxation 14 times. All the rest is much less. So, conclusion that one can draw from this is that climate change has not been a major issue yet in dispute settlement. That also becomes clear if you look at advanced disputes. Yeah, and then we are a bit broader, not just climate change, but trade-related climate measures. There are these, and should be happy to conclude that we've actually in this course we've discussed them. Most of them. US gasoline, yes, we talked about that briefly, because in that case, the exhaustible natural resource was clean air. We have Canada, global energy. We discussed that one too. We have India solar cells, and we have EU palm oil. The one that we haven't discussed is US renewable energy, the case brought by India, but India and the United States eventually reached a mutually agreed solution as part of the big love affair between the United States and this is a indication that I have to stop. Okay, right. I will. Now, there are pending disputes, and pending at the moment is only one, and it's even pending in a rare way, namely the case brought by China against the United States of safeguard measures on solar energy products. There was a panel report against the United States, and the United States appealed it to the void. Yeah. So it's pending, but don't expect anything to happen. And then there are looming disputes, and I've referred to those. The looming disputes, actually, there's one pending missing. How did that happen? My apologies. There's, of course, the US IRA case that should be my fault. I don't know what happened here. There are looming disputes and CBAM, yeah, but also, and I think that may come sooner than, although it's the application implementation has now been delayed by a year, it may come sooner, and it's so definitely does more harm to India than CBAM. Would be the EU deforestation-free products regulation. Prospects for settling disputes on trade-related measures in a peaceful and rules-based manner. Well, the prospect is the MPIA. The MPIA or other Article 25 DSU appellate review. That's what happened in the Turkey pharmaceuticals products case. Turkey was not a member of the MPIA, not a party to the MPIA, but yet they used a procedure, an appeals procedure that was copied on it. Turkey and the European Union agreed on that. So that's a possibility. So it's a sort of ad hoc MPIA. That is possible.
But this DSU mechanism, that would be a multilateral channel and a unilateral one if we use that way.
Oh, not really, because also the MPIA is based on Article 25. Yeah. I see where you come from. Yeah, but it's a dispute settlement method that is provided for which there's room in the DSU. Now, why would I definitely categorize the MPIA as a plurilateral system? Because there you have already a limited group of countries that has permitted itself for any future dispute to have this appeal, this interim appeal process. If you have ad hoc use of Article 25 DSU, I'm actually thinking aloud and coming to where you are already. I think indeed you could call that still.
The current parties to NPI can they still make use of this ad hoc mechanism?
Can it make use of?
The current parties of NPIA, can they still make use of this ad hoc system?
No, they can't. Well, they can't in disputes among themselves, among parties, among NPIA parties. No. But there's a degree of flexibility within the MPIA arrangement itself. So, right. This brings me to the last slide. What to expect from the WTO and what to expect from WTO law in the fight against climate crisis? Well, we have very difficult years ahead. Years with huge uncertainty. As a result of the fundamental changes in international politics and changes in the global economy. And I would now add, also as a result of the person that will become US president in a few weeks from now. We'll see more recourse to unilateral action and more disregard for WTO law. There was a time that whenever legislation was discussed in the US Congress, that there was at least somebody who said, well, is this WTO consistent? Shouldn't we worry about that? Well, that's long ago. That's the last thing that you will hear anybody mentioning in congressional debates. And they've done studies on that. I'm not just inventing this. It's still very different in the European Parliament. European Parliament, when they adopted CBAM, there was a lot of discussion on whether this is WTO consistent. The Commission had to defend itself very strongly and say, yes, this is WTO consistent. Rest reassured, we've covered our bases. But we'll see more disregard for WTO law. Does this mean that WTO law is not worth studying anymore, that it's not worth? No. I mean, in many circumstances, WTO law will still be respected. And you need to know, at least when it is not, you need to know what the rules are that are not being followed. We will see in the years to come, we will see more geoeconomic fragmentation. We may fall apart in, and where will India be? India will probably try to steer an independent course as they've been doing. But that's also what the European Union wants to do. We'll see more fragmentation. I think we'll see more recourse, whether India agrees with it or not. We'll see more recourse to plurilateral negotiations and plurilateral dispute resolution. Jump on this train. If you don't jump on it, it will run over you. There is a need for institutional reform and updating of the rule book. That is not so much to solve the problems. I'm not that ambitious anymore. But to at least manage and mitigate the current challenges. There's a difference between solving problems and mitigating them, managing the problems. And I think that's where the WTO can play a role in the climate crisis. I don't envy you. I'm retiring. Well, sort of. But you're at the beginning of your professional life. Only thing that I can hope, keep the faith, hope for the best. Thank you.